Hello, Colorado Realtors. Thank you for joining me for another edition of Legal Bites. I'm Scott Peterson. This is actually our first Legal Bites of the 2017 calendar year. We slacked off a little bit in January because we had some other things going on, but you can count on these coming forward about twice a month, maybe 3 times a month for the duration of the year, because they've been very well received, and I'm glad you all are enjoying them. Today on Legal Bites, we are going to be talking about a brand new e-rule that has literally just gone into effect on January 30th. So just a couple of days ago, Rule E47 related to competency went into effect. I want to take a second and read the rule to you. It's just a quick little paragraph, but it's got some pretty big implications. So bear with me here as I quickly read the new competency rule to you. So in any occasion where a broker is engaging in the practice of real estate brokerage, pretty much anything you're doing, a broker must determine whether or not he or she possesses the necessary experience, training, and knowledge to provide brokerage services and maintain compliance with the applicable federal, state, local laws, rules, regulations, and ordinances. If the broker does not have the necessary experience, training, and knowledge, the broker must either decline to provide brokerage services or obtain the necessary experience, training, and knowledge, or obtain the assistance of a supervising broker or legal counsel, or co-list with another licensed broker who does have the necessary training, experience, and knowledge. So that's all the rule says, but what are the implications of that? I'm guessing that many of you sort of recognize some of that language from something previous. So nothing's changed with license law, and there has always been an expectation in license law that governs your license and your ability to practice real estate brokerage that you're going to act with a level of competency, that you're not going to be incompetent, essentially. And then we had commission position statement, which is different certainly than the e-rules. Commission position statement was an articulation of license law, really, to clarify that you had to be competent. But there wasn't any rulemaking that went into place. It was an authorization by the Real Estate Commission, or the Real Estate Commission instructed the division to essentially write a position statement trying to articulate license law. That was just a couple of years ago in 2011. Well, the commissioners determined very recently, and again, this new rule just went into effect on January 30th, that Rule E47 was an important supplement to our rulemaking, to the e-rules. And it's going to make it easier potentially for the commissioners in the event that it's determined through an investigation or complaint that a broker hasn't been acting competently or has been acting incompetently, that they're in violation of a specific rule. And so there's potentials for implication there. Or there's implications to the implementation of this rule is what I should be saying. So why address competency as a rule? Well, in Colorado, we've only got one kind of license. That's, you can sell, if you're a licensed broker in Colorado, you can sell real estate all over the state. You can do commercial residential transactions. You can do leasing. You can do property management. You can do kind of the whole broad spectrum of things because there's only one real license type. Of course, there's subcategories of employing broker, independent broker, or broker associate, but there's only but any one of those licenses gives you the ability to work on any transaction. But the point is, through this new rule, is you have to be competent to do what you're doing. So what does it mean? Well, if you're a residential broker and you've never performed a commercial transaction in the past, and you've only sold residential properties as an example, you probably really need to be thinking twice before you go and represent a retail client on a retail lease in a commercial transaction. You know, long-term retail lease that might have options in it. Might be a triple net lease. It might be a gross lease. It might have percentage rent requirements. A lot of things that you wouldn't necessarily be competent to negotiate or represent a client on the basis of if you've only done residential transactions, as an example. Property management, of course, is fraught with peril from my perspective, and your brokerage license enables you to perform property management duties. But if you don't have the experience and the capabilities to understand the additional obligations and trust accounting and some of the things that come along with property management, you shouldn't be performing it. And if you screw it up, you're going to be in violation of the new Rule E47. Same could be said maybe with high-dollar properties or luxury properties. If your experience has really just been handling, $200,000, $300,000 condominiums or single-family homes, you maybe ought to be thinking twice before you dive into an exciting new listing to sell a 6 or maybe 7-figure property. Bring somebody in to help you with that, co-list it or refer it out. Out-of-market deals, I see this a lot. Brokers trying to do a deal in, they're a Denver broker, but maybe they're trying to do a deal, buy a condo for their friend up in Aspen. Probably a great deal, probably lots of great financial opportunity related to that deal, but maybe you don't know the market. Maybe you don't know the implications of of a transaction that you're going to structure. If something is good value for your buyer, you don't have access potentially to the MLS. Some of those things would potentially be violations of the new E-rule. And then, of course, investment deals can be incredibly complicated. So I don't tell you all this to scare you, but these are the types of things that it applies to as the commission. If a complaint gets in front of them, these are the kind of things that they're going to be thinking about. What's your experience and background? And did you take on an opportunity, a brokerage opportunity that might have been plenty lucrative, but you don't have the proper training that is necessary to do that? If you're going to take on something, you got to either, as the rule says, bring somebody in that has the proper experience, obtain the proper experience through education, working underneath another broker that has that experience, or you got to refer the deal out. But don't get caught in violation of Rule E47. The antenna's up for that, and there's a reason that this rule was promulgated and passed by the commissioners. So understand the implications of it. Be very, very cautious. As a general rule for best practices, stay in your zone. Don't try and do deals out of market if that's not your experience or your background. Don't try and do commercial leasing transactions if that's not your experience and background. Either get educated, matriculate yourself into that market in a responsible manner, or refer the deal out to somebody that does do that. So stay in your zone. Don't be afraid to refer a deal. Don't be afraid to bring in help. It may cost you some of the commission, but it'll keep you out of trouble with the real estate commissioners. And you want to avoid that always. And then learn. You can always get education. You can always bring your competency level up to a point where you're capable of handling those transactions. But until you do that, make sure that you're not doing things you shouldn't be doing and thereby potentially violating Rule E47. Hopefully that helps. As always, if you've got questions, the legal hotline is available 9 to 12 and 1 to 4 to employing or independent brokers or people that are designated by their employing broker to call the legal hotline. We're always there to kind of help you and kind of guide you in the right direction and hopefully get you pointed in the right area and not let you get in trouble with license law, with the real estate commission, or in some sort of civil action with your clients. So act cautiously. Thank you for joining us, and we'll be back in the next few weeks with a new version of Legal Bites. Thank you very much.